Sri Lanka's most powerful news brand.
Speaking to News First, Attorney at Law Kanishka Vitharuna explained the possible pitfalls of the new foreign exchange regulations.
Act number 12 of 2017 grants approval for 3 groups to engage in foreign exchange transactions. The first group is commercial banks, the second is restricted dealers, and the third is a dealer who receives special permissions for specific purposes as may be prescribed by the minister. When considering if money laundering could occur through this act, we need to consider if money earned illegally in another country could be used to acquire property in this country. Such an individual could make an investment in a company or acquire other properties. We don't know how money is being earned abroad. Such persons could use the 2 new types of dealers to invest in something and in the process turn black money into white money. If that happens, our country will become a haven for such activities. There are very limited actions in this act to stop something of this nature. There are plenty of foreign exchange reserves out in the world that have been earned through illegal means. There's plenty of black money in terrorist groups and extremist groups waiting to be laundered. Through the provisions of this act, these groups could potentially use this money to invest in properties in this country, turn it into white, and then take the money out of the country once again.
The Attorney at Law also explained about the fate of legal cases regarding foreign exchange fraud filed under the previous legislation.
When this act was brought forward, there were issues as to what would happen to the cases filed under the previous legislation. Article 30 of the new act states that all suits, actions and proceedings instituted under the repealed act shall be deemed to be suits, actions and proceedings instituted under the repealed act and be heard and concluded under that act, and all investigations and inquiries instituted under this repealed act shall be deemed to be investigations and inquiries instituted under the repealed act and shall be concluded under that act within a period of 6 months from the appointed date. This means that the new legislation will have no effect on cases filed under the previous legislation. However, cases which have been heard or someone who has been freed under the previous act based on a technicality have not been covered by the Article 30. We all know that a famous minister had a similar case against him filed under the previous legislation. He was freed based on a technicality pertaining to a charge sheet. That case stopped there. So when the new legislation came in, this particular case won't be considered as an active case or an active investigation. That is what I believe.